brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
Okay, the judge already struck my motion, so now I need to do something. What I'm going to do is I'm going to enter a motion for a hearing, and I was wondering if I attached my motion for dismissal merits into that motion, but not specifically in reference to a dismissal, if that would be wise, just to get it into the record again. Or would he probably just strike it again and it would be fruitless?
Okay, what is the true mistake? Okay, let's look at that before we look at the voodoo. Let's look at the logic. Okay, so where is the logic error so far? Okay, without thinking about voodoo, let's identify that.
That I need to request permission from the court to do something?
What?
The fact that I have to request for a hearing, basically.
Again, you're reaching to voodoo. I'm trying to discuss what in terms of the conversation at hand, okay, and them striking your motion, okay. What is broken about the conversation?
That he said there was no merits, and there clearly was.
Okay. Well, that's okay. So that error does what?
It removes my valid and relevant meritorious claims from the record.
Okay.
From being
so
addressed.
There's two roads ahead of you. One that would be gone down if they face reality and logic, and one that has gone down when they don't, right? So what is the difference between these two roads?
Well, one of them is when you're dealing with a person or a human that's reasonable, and one is when
what is the
somebody is
difference
tyrannical.
between the end of these roads? Not what they look like along the way, but what injustice is created by this?
Okay, well, the second option would lead to harm against me regarding having my license suspended. And I would have to follow up with some kind of an appeal, apparently, to address that.
Okay. The way to correct it is a separate issue. Okay, so let's not address that yet. If he proceeds with this point stricken, with this motion stricken, that he proclaims has zero merit within it, okay, then you are left without a way to communicate, to move for a conclusion that is based upon the merits that you've listed. Okay? So the error where he thought there was no merit in something that did in fact have merit creates an injustice in that the merited position is ignored in favor of ignoring the merit, which creates a bias of benefit for the prosecutor, right? Okay, so that's the logical discourse problem at hand, right?
I see what you're saying now. So the judge is acting on behalf of the prosecutor.
Not quite.
And
that's a little bit. Don't just round up. I mean, it creates a benefit for him, but it doesn't mean he's acting on behalf of. You know what I mean? It could be. There are other reasons that he could be creating a benefit for the prosecutor. It could be mistaken. It could be accidental. It could be incidental. There's all kinds of things.
Okay, I get you.
But the fact is, it creates a benefit for the prosecutor. That much.
Right. That's the result.
This error where he's mistakenly believing that there's no merit when the merit was listed, perhaps as a mistake where he believes insufficient merit is equivalent to no merit, or what he believes insufficient merit. What he believes to be insufficient merit to be treated as the same as no merit is creating a problem with you because it removes your ability to have his judgment questioned about the sufficiency, and removes your ability to, have it reviewed by other people. Because with no merit, it gets stricken. With a little bit of merit, but not enough, it doesn't get stricken, it gets denied. Right. So we know he's taking the striking instead of denial, and thus creating a huge benefit for the prosecutor that is undue, that isn't deserved to the prosecutor, and furthermore cannot be remedied if permitted.
So if he
because
denies,
once it's stricken.
If he denies because of lack of merit, then it's going to be stricken?
No. I'm sorry. Yeah, this isn't. I'm sorry if you're not up to speed on what was going on between that. But so the judge wasn't moved by the merits of a motion, but instead of saying that it was not sufficient, he proclaimed that the amount of merit in it was zero, absolutely zero, no merit whatsoever.
Yeah.
Okay. As if you've not mentioned any merit, anything with merit of any sort. And the right thing to do for something that is completely without merit is to strike it because it's not relevant. Okay, but he's using that to get rid of something that just he doesn't find has sufficient merit. He is not compelled to decide in your favor. But he's using a mechanism to get it off the record entirely. So the problem between striking it versus denying it, right? Now, the thing about it is a denial in a discretionary instance would be you'd be almost as screwed. But here we are talking about not the denial, the denial of if I remember right, the denial of the thing is where you're proclaiming that there was no evidence of standing, no evidence of, applicability of law, right? No evidence of jurisdiction, basically.
Specifically, he said that he finds that the motions are without merit as a matter of law and should be stricken.
Okay, if you're going to back up, okay, I'm sorry, stay with me here. Let me try that again. Okay, so where was I? So the motion itself that he found no merit to, okay, was a motion to strike, right?
Right.
For failure to state a case. Is that the one? What motion was it?
I'm trying to pull it up now. I believe failure to state a case was one of the elements of that motion. I believe there was regarding jurisdiction as well.
Okay, so it's the demur. It's a demur motion, right? It's the motion to dismiss, right?
So last time we went through this, it was we kind of discussed the interlocutory appeal in regards to dealing with it, and I've tried to make some inroads with that, discussing it with the clerk and also who the clerk pointed me to, which was the state bar.
Okay, can we hold on to that? Can we hold on to that conversation for a minute? The motion in question is the motion to dismiss, right?
Correct.
Thank you. Okay. So, and he striking it because he found no merit. Okay. And that's it. He found zero merit, not merely insufficient merit, but zero. Okay, so instead of denying it, he struck it. The question becomes as to the difference between striking it and denying it. Okay, and the question is about zero evidence versus some evidence, right?
Or
now,
invalid evidence. That's, I guess, what he would be claiming.
No, invalid evidence. What? I'm sorry. Did he say that?
No, but I mean.
Okay, don't put words in his mouth. That's gonna. Okay. Okay. So no evidence versus invalid evidence is completely unrelated to each other, right?
Yeah,
He said no merit. No merit. He didn't say
that's right.
he found your merit to be a lie. He didn't say that he discovered otherwise. He didn't say that, you know, your merit was countered by evidence to the contrary. Any of that, right? It was just that he
Right.
could find no merit. And as a result, because he could find no merit, he chose to strike it, to remove it from further review and consideration.
But doesn't, I mean, from the judge's perspective, it all comes down to seeking his permission, right? Like I can say do this, but in his mind, he has the final say so, and so he can just say no. The way he sees
believes
correct?
he believes that he has that his opinion matters because it matters in a lot of things.
Yeah.
The judicial discretion is almost everywhere in court. The problem is there's a couple places that it's not, and they don't know what the fuck to do when they come across those. The main place that they don't have discretion is in hearing a case that they don't have jurisdiction over. That is the big one, by the way. They don't have discretion to hear a case they don't have jurisdiction on. And they don't have discretion to imagine themselves to have jurisdiction. And they don't have discretion to decide if they have jurisdiction. If they decide that they have jurisdiction over a case they don't have jurisdiction over, they still don't have jurisdiction over it. It doesn't change anything. They either had jurisdiction to begin with, in which case they're being redundant, or they didn't have jurisdiction to begin with, in which they're saying something irrelevant. So it's either, for them to decide that they have jurisdiction is either redundant or irrelevant. One of those two. Motion to unstrike and reinstate, by the way. On the grounds that striking a motion merely because he believes it has insufficient merit, if that's what he meant. But he said he found no merit, which means that he had a corrupted copy or something, is all I can think of.
Well, he says, let me pull it up again real quick so I can get the wording right. But I'm thinking that the way he worded it regarding in law, facts in law, that there's some kind of a law.
Hold on. You're saying that there's a phrase called facts in law, right?
Yeah, I'm pulling it. Hold on, I'm pulling it up to make sure I get the wording right. Okay. No, he says as a matter of law. The motions are without merit as a matter of law. So he's basically saying merit.
Okay, hold on.
That the matter that the law.
Hold on, don't move on from that phrase. If you found that phrase important, let's go over it for a second.
Okay.
As a matter of law, what the fuck does that phrase mean?
That's his claim right there, is because it says
okay.
And should be stricken.
I don't know what that means. You're saying that's his claim, and I'm telling you, I don't know what that phrase means. So you're saying his claim is something that isn't yet clear, right?
It's ambiguous, basically. And
well,
whatever
I don't
the merit,
know if it's ambiguous. It sounds a little bit more like it's nonsense. But
okay, let me try and break this down in my understanding. See, without merit is the grounds that he's claiming.
Okay. That phrase I understand.
As a matter of law.
Keep saying that. What does that mean? Okay, go ahead.
I'm just breaking down this sentence the way I understand it. So as a matter of law is whatever voodoo he's using to basically be able to say that my merits are not merits.
Saying that it's okay, saying that's voodoo doesn't really, I mean, I understand that. Matter of law.
And should be stricken. Okay. Yeah, and should be stricken.
Okay, don't move on. Don't move on, because the voodoo part makes the rest unintelligible. Once you come across a part of phrase that you don't understand, this is a highly regimented understanding. You don't just get to read the rest of the sentence and try to imagine what it might mean, right? As a matter of law, What is that as a matter of law? Is he's proclaiming something to be real that isn't real? That's what it sounds like. But I get that cleared up. So is he saying legal reality is different than actual reality in this instance? He's not concerned with actual reality, as instead diverting deliberately from actual reality. That's where my mind goes with it. But I don't know. I would ask his confession. As a matter of law, as opposed to, or in contrast to, as a matter of reality.
It says that I just Googled it basically, and it says that.
Are you saying that whatever Google tells you is what this judge meant?
Is determined by the considerations of legal principles. You don't know
Are you
that,
saying?
but I'm just saying what the law, what the community is saying is the common understanding of that phrase.
Okay.
Okay.
What is? You got Skyped a little bit? Say it again. What was the definition there?
Okay, well, there's a more simple one here. It just says a matter of law definition, an issue or matter to be determined according to the relevant principles of law, which
That doesn't
they
mean
would be
either.
statutes.
That doesn't mean anything.
Statutes, rules, court decisions.
Again, that doesn't mean anything at all.
I think he's
again,
saying that, I think he's abusing precedence is what he's doing. I think that there's other.
I understand exactly. I mean, yes, I know the goals that he has. The goals that he has is to substitute his opinion for reality. I get that, but let's make it clear rather than vague. Okay.
So you're wanting to come up with a question to deal specifically with that to submit to him? He's
saying as a matter of law, is that opposed to reality and ethics? Or is that somehow, what does that mean as a matter of law? See, he's saying he finds no merit as a matter of law. Does that have it? Okay, so is he confessing that in reality there is merit, but in law, in his opinion about reality, there isn't? You see, I'm sorry. Let me try this again. To me. I understand that, but and I agree. What it sounds like to us is probably pretty easy, but what I'm trying to get at is, unless you get their confession to that, it's useless speculation. You can't use your speculation about what he might have meant. His confession about it is a different thing. So, remember that lawsuit where the guy was legally dead, and as a matter of law was dead, right? When he was actually alive. Your motion, he's saying, as a matter of law, has no merit. The question becomes, that aside, does it have merit in reality? Actual reality doesn't have merit. He's simply saying,
I understand what
is it relevant? Okay, so then the question starts becoming, okay, so if we discover that in actuality it has merit, but in your opinion, it doesn't have merit in law, whatever that means, then
I mean, I
then are we disregarding reality in favor of his opinion? That confession. Are we disregarding reality? So the actual events, my actual motion, reality having listed merit, is being ignored deliberately. Is that due process when reality is ignored in favor of his opinion of law? Which, incidentally, doesn't presume your innocence. It is presuming your guilt. And is that due process? Is that kind of coming together for you?
Yeah. I mean, I see the direction where we're heading here. I mean, there's a dichotomy there of reality and his opinion, and we're trying to word that and bring it into a matter that can be addressed regarding due process. How can we word that into a question for a clarification to get a confession that puts the finger on the violation of due process?
I think that once you understand what I've just said, you might have a question, or it's easy to stay at that point. But I don't know.
Okay, so now do I put that question in my pocket for when I'm in front of the judge?
I'm sorry.
I submit some paper.
What is the reason you would wait? Is it to avoid work? Granted, you're only dealing with a $400 issue.
Okay, because tomorrow, if I don't do something, then he's going to start the process of having my license suspended again, which is going to be a clock. I always have a clock.
Okay, I get that, which is why I was kind of wondering why the hell you thought about waiting. Why the first thing that came to mind was waiting, rather than writing or communicating. I should say.
Well, I'm not understanding what you mean by waiting. I just got the motion or the order that denied my motion a few days ago, and I've been trying to process this on how to go forward. So.
I'm sorry. The last question I recall you asking, forgive me if I misheard you, was about whether you should do something to get this question asked, or whether you should wait till you see the judge.
Okay.
And my explanation was purely in recoil to the question of being, how long should I wait? It's a common question around here. We hear it once in a while about people saying, hey, how long should I wait for? And the answer, like most things, is pretty much zero, unless you're actively writing or have something else that precludes you from doing.
The
right amount of time to wait is usually zero.
So basically, every time I come up with a question, I need to be asking it in some written form. Like I have a question. Let me here and then submit it.
In some communicated form. I don't know if written is always necessary, but communication is always necessary.
I have access here in this county to email with regards to the clerk, so it would be convenient that way. Okay. However, there's the lack of accountability. They could simply ignore my emails, and I wouldn't really have a lot of evidence to support that I submitted it, or they got it.
The thing about email is it's very difficult to prove delivery. I can attest to that. It happens all the time.
So I'm going to submit the request for hearing, and I'm going to also submit. I'll have to wait till tomorrow. I'm going to submit the email regarding a clarification with what we discussed tonight for that striking of my motion, and then I will start to hold on. I'm being distracted by this. I will start to process my clarifications with the court in a communication more frequently than I have been. And then when I go to court, I will just deal with the clarifications that I've been putting forward instead of waiting and actually pulling them out at court. They'll already be in the record, and I will just address them essentially.
Right.